Mr. Graddy, please step forward, my friend. Good morning.
You offered to, if there's questions for Jack, do you want to wait till probably makes sense that the commissioners have questions from an engineering standpoint, plan project, to ask at the end if you have something for Jack Moran and Diamond there.
Good morning.
Hey, good morning.
My name is Hank Graddy. If I had known Dick was going to wear a black sports coat and khaki pants, I might have changed uniforms so that we wouldn't appear to be on the same team.
You can take your tie off, we don't care.
I want to ask you to, if you are a supporter of data centers, I want to ask you to consider what Tanner told you. He went to his presentation to the Planning Commission and announced some numbers. Last week, it's my understanding from reading the transcript of the presentation, you all talked about a community benefit agreement. I'm glad you had that conversation. I, in my presentation regarding the text amendment, asked that the text amendment for data centers include a requirement for a written community benefit agreement. Your text amendment did not include that, and to my satisfaction. It was inadequate in that area as it was in so many other areas. But it was good news for me to hear that another attorney that you've hired was in the process of trying to negotiate a community benefit agreement. Where is it? Where is the document that takes the promises that Tanner made and puts them into an agreement that the community can count on, other than a promise made at a planning commission meeting? I read the promise, a promise of $1 billion. But it's a promise that we don't know who actually gets the benefit. And that's what the community benefit agreement is intended to do. Now, I was told that if we had second reading by May 22nd, that wouldn't be time enough to get the community benefit agreement hammered out. That all we would have today are bullet points. I haven't seen the bullet points. Do you have bullet points that you have received hammered out, putting the promises of the data center to the community in writing that is binding and enforceable? Don't you think you need to postpone giving second reading to the ordinance until you hammer out that agreement so that the community can enforce, can count on, can know what the real benefits are, not promises made at a public meeting and promises made to you, but something that is enforceable? What is the rush? If you are, in fact, for a data center, what is the rush? You've got 90 days to make a decision. You gave first reading a week ago. This was voted on April 1st. You've got time to hammer out an agreement so the people in this room that are worried can get some assurance. Some of you who have signed NDAs know who the entity is, but the rest of us who have not signed NDAs are still in the dark regarding the mystery applicant. I, as an opponent, would urge you who support it and those of you who are skeptical to agree on one thing. Postpone the second reading until you have the community benefit agreement in writing and in front of the public, so the people in this entire community can know what the benefits are. Not how much this particular data center is going to be spending for its own benefit. And I'm not surprised that they want to build a large water facility so they can have a lot of water, and they want to build a large waste treatment facility so they can treat their waste. that makes perfect sense, and they want to build roads so they can service their application. What is the benefit to the community of Mason County? We know they're going to benefit themselves. They're going to spend money to make themselves more money. That's what they do. That's why they're the Fortune 500, Fortune 50 company. But what is the benefit to Mason County? And where is that in writing? My understanding from last week is that your attorney's working on that, but he does not have it ready today. All we're going to have today were bullet points. And so I ask again, do you have the bullet points? I mean, I'm asking and pausing, hoping for an answer.
Sorry, this isn't a question or answer session. It's your presentation, Mr. Graddy. Please continue.
If I could.
Thank you.
Members of the Fiscal Court, I wanted to begin by asking about the community benefit agreement and something that I thought both proponents of the data center and skeptics and opponents of the data center could agree on, and that is that before second reading is given, it's in the interest of the entire community, supporters and opponents, to delay for at least a month and hammer out the community benefit agreement so that the promises that have been made can be reduced to writing and are known to the community. And then there's a second part of what I would urge the fiscal court to do, along with giving yourselves and your attorneys more time to hammer out an agreement, and that is, I would ask you, as part of the agreement for this community, that you ask the applicant now, before you give second reading, to release the non-disclosure agreements and identify itself. The mystery project has been a mystery for most of the community for too long, and it's time to bring the mystery to an end. Nobody should be allowed to seek a zone change without identifying who they are. And I believe trying to get a zone change hiding behind the Economic Development Authority so that you can remain anonymous is not legal, and we intend to challenge that unless you all fix it. And the way you fix it is to say that the application that is before you should be sent back to the Planning Commission with instructions that the actual applicant for the data center needs to sign the application, identify himself, and apply for the application. The applicant who is proposing to come in and change your community dramatically needs to identify itself to the entire community. And it should not be to a select few who have promised that they will remain anonymous because they are apparently supporters of the project from day one. I would ask the fiscal court to require the applicant to reapply and identify himself to the community as a whole. I should have done this in proper sequence. First, I identified myself as Hank Graddy. I do want to express my appreciation to John Estel and the fiscal court for agreeing to have argument hearing before you vote, give second reading on this matter. I think that was a courtesy that you extended us, and I want to express my appreciation. And I don't want Tanner to win points because he's so grateful to be here in Maysville. I too am equally grateful to be here in Maysville this morning. All my other trips up have been either in snow or sunshine, but it's been sunny driving up, Today it was soaking wet driving up, which is, we all want, of course. But it's good to be here at Maysville. I love Maysville just as much as Tanner does. I mentioned the community health benefits, and I mentioned that because that is something that I think you're close to doing right, but I would urge you to time it correctly, delay the vote, and get a community benefits agreement before you vote. You have leverage before you vote. Once you voted, you have lost all leverage. So your bargaining position is strong now, and the moment you cast a vote for second reading, your bargaining position as a negotiator of an agreement basically evaporates. You've got nothing more to negotiate with. So why would you give up your negotiating position before you have your agreement? I passed out two things, and I want to make sure the record reflects that what I've passed out. The first is my March 25th letter to the Planning Commission. So this is something that is also of record, just like Tanner's presentation was part of what he presented to the Planning Commission. The second thing that I passed out to you, it may catch you by surprise, and I'm pretty sure that it is admissible. It's a case. It's the case of Kalin versus Louisville. This is a Kentucky Supreme Court decision. I cited this to the Planning Commission before the hearing on the 25th because there was some question about whether or not I would have the right to cross-examine the applicant. And the Planning Commission, going into that meeting, had announced that there would be no right to cross-examine, that questions would have to be asked to the Planning Commission, and then they would ask the questions to the witness. And I cited this decision and other decisions that have affirmed the constitutional right to cross-examine the applicant in a zone change. This in Kalin, it's a 3-page opinion. It's wonderfully short. I don't know how many Supreme Court decisions you've read, but this will be the easiest one probably that you've ever read. Again, because it's so wonderfully short. But it holds out as a Kentucky Article 2 constitutional guarantee. That is, it is sufficiently important that it grounds itself in the Kentucky Constitution, Article 2, the protection against arbitrary government action. And that protection requires the right of cross-examination. And the right of cross-examination must be afforded in a Planning Commission meeting. And when I cited this to the Planning Commission lawyer, he agreed. And I was given the right to cross-examine the applicant. Much to my dismay, at the Planning Commission hearing, when I went to cross-examine the applicant, I got Tanner, who was the last thing I wanted to cross-examine. He's a lawyer who, I think he acknowledged he had never been to a data center. He wouldn't tell me the name of the applicant. I said, has the applicant, or has the person who wants to come to Mason County and locate a data center here, has he ever been sued for nuisance? I don't know. Have you ever been to any of his facilities? No. How long have you been in the case? 4 months. I got nothing in my cross-examination of the applicant about who the applicant was, what his track record was, what was he going to need from the community, take from the community, what was he going to give to the community. Basically, all Tanner could do was say, here's my presentation, you know what I'm going to say. He was there on behalf of the Industrial Development Authority and not the actual data center developer. Now, I objected to the Planning Commission that allowing the applicant, the actual data center who is behind this project, to hide as a mystery project behind the Mason County Industrial Development Authority, I thought violated the law and my constitutional right to cross-examine the applicant so I could know who he is and what he really is bringing to this community and what is his track record for keeping his promises. We still don't know that because I was not allowed to cross-examine the applicant in the hearing on this matter because the applicant remains a mystery. I believe that is a denial of my client's due process right. I believe it's the right guaranteed in Kalen, and I believe this is a flaw in this proceeding that will require that it be set aside unless you fix it by saying this was not handled properly. It should go back to the Planning Commission. The Planning Commission must require the applicant, the actual data center, the Fortune 50 company, to identify himself and show up at the Planning Commission and take cross-examination, submit to cross-examination. This is the only opportunity the public has to ask the data center, who are you? Are you reliable and trustworthy? Are you going to take advantage of us? Are you going to keep your promises? We have no way of knowing that until it's too late, unless you all stop the process now and send it back and ask that it be done correctly. So I've given you the Kayla decision. I'd like you to now look at my letter. And we'll go through this. I'm just going to mention, I'm not going to read it. I'm confident you've read all of it carefully. But the first point that I made was that the Mason County Industrial Authority is not the real party in interest, and the application should be dismissed until the real party in interest signs it and applies for a zone change. The second point I made, and this point, I would actually, you can find some of this language in the findings of fact that the Planning Commission has sent to you. You'll notice in the Planning Commission's findings of fact, there is a discussion of the staff report by George Larger. And in the staff report, he acknowledges that the comprehensive plan of this community does provide a basis to turn down the zone change. He also agrees with Mr. Nichols that you can go through the comprehensive plan and find language in the comprehensive plan that Mr. Nichols has cited that allows him to argue that his application is in agreement with the comprehensive plan. But I want to try to make that point, our point, more clearly than it is in the staff report. Your comprehensive plan is absolutely silent regarding data centers. There is no authorization for data centers in your comprehensive plan. It doesn't mention data centers. What it does mention, and Mr. Larcher noted this in the staff report, it mentions protecting farmland in Mason County, protecting prime farmland in Mason County. Now, one of my criticisms of the text amendment that you all have adopted and that I have filed suit on is that you went backwards. You amended the text before you amended the comprehensive plan. Kentucky law, I believe, requires planning before zoning. And I believe the law required that the officials of this community amend the comprehensive plan so it would provide for data centers discussion. Where should they go? How much data center do you need? What is too much? How do you know when you can say no? I mean, once you open the door, how many data centers are going to be allowed in Mason County? I mean, after this one, what's the limit? Are you going to have 10 data centers? This one's only taking 3% of your prime farmland, but if you have 5 more, that'll take 15% of your prime farmland. But your comprehensive plan is silent. The comprehensive plan is the document that analyzes what does the county need? How much data center, if any, do we need, and where should it go? That part is completely missing from your analysis because you've done it backwards. you've amended the text before you amended the comprehensive plan. So I complained to the planning commission that they had to turn this application down because it clearly was not in agreement with the comprehensive plan, because data centers aren't mentioned in the comprehensive plan. There is no authorization for data centers in the comprehensive plan. And that is easily fixed. Max Moran, on behalf of Weir Mason County, spoke to the planning commission last September, urging them to adopt a text amendment that would spell out the discussion of data centers. Said, this is needed. If they're coming, the comprehensive plan needs to be amended. My understanding that, Judge Executive may have been in the room when that discussion took place, but that you were on the comprehensive plan review committee, you could have brought up the need to amend the comprehensive plan to address data centers. That never happened. And so now a zone change is in front of you that claims to be in agreement with the comprehensive plan that is absolutely silent on data centers when the comprehensive plan was urging that it address them, and that urging was ignored. So you all, I think, are creating an illegal action if you go forward with this. And I think it's in the community's interest that you send this back to the planning commission with instructions to amend the comprehensive plan and then deal with data center text amendments and data center map amendments. You'll see below those first 2 points, I'm now on page 4. There's a series of specific objections to the application, and I don't know that I omitted anything. Frankly, everything I found about the application was inadequate, clearly not in agreement with the comp plan. It does not, the application does not comply with the data center ordinance. Descriptions are insufficient, stormwater protection is insufficient. So I'm not going to go into all of that in detail. I do want to go to page 7. The comprehensive plan comes first. Planning must precede zoning. A final point that I want to make, just a minute. It was just here. Okay. I complained earlier about the Industrial Development Authority being the applicant and not being the proper applicant. I've handed the clerk page 1 of the application, and it has signatures. These, I think, are signatures from the Industrial Development Authority. And then it has property owner signature certifying that the applicant has authority, see Exhibit F. And so I've attached to this first page of the application Exhibit F. And Exhibit F are signatures of property owners, and it says, by signing below, the undersigned acknowledge and agree to be bound by the terms of the zoning map amendment application. It has the signatures of all of the people that have signed, the 28 property owners. None of them are signatures certifying that the applicant has authority to represent them. So this signature is another defect in the application because it is not designated the applicant as it says it has. So I believe that there are many defects in the application. There are legal defects and factual defects, but more importantly, I believe that that you have before you a zoning ordinance that claims to be in agreement with a comprehensive plan when it's not. And then they claim that if not, there have been major changes that have changed the character of the area. And what are the major changes that they cite? technology changes. Technology changes are not a major change in the character of the area where they're proposing to put this development. That is not the kind of change that KRS 100-213 authorizes. So for a variety of reasons, the findings of fact made by the Planning Commission are inadequate. And for a variety of reasons, this fiscal court will serve this community first by delaying taking action until the community benefit agreement is completed, and then sending this matter back and requesting the Planning Commission to update the comprehensive plan to address data centers, and then after that is done, look at your text amendment and amend it to conform to the comprehensive plan, and then consider zoning map amendments. Now is not the time to consider this amendment. Right now is the time to send this back and get things right before you proceed. I would like to pause and recognize Max Moran, who is the president of We Are Mason County, to see if he has anything he wants to add. May I do that?
You got, yeah, 2 minutes, yes, sir.
Max? Yep. You have 2 minutes.
Yeah, just like I had last year too, it's no big deal to that. But I'll just be short, guys. When we started all this stuff, it wasn't about saying no. It's just like what Hank was saying, trying to protect our community. The decision you four do today is gonna have effects way beyond the scope for this project here. And it's not about these guys. The fear is it's the next 4, the next 5, 10, 20. Because the decision on you voting today, the next companies, when they come in, they will do exactly what you say that's on paper. That's why I said that, on paper, because there's already people across the county, I don't know if you know, Judge, Commissioners or not, they're being called now for more all over the county. Transformer substations, 50 acres, believe it or not, in one spot, for more of these to come in. Personally, I don't think it's in our interest to be in an industrial county that makes nothing. Judge, you've overseen many businesses that have come in here. EnviroFlight, all the other ones out there, PPI, all of them. That's the type of stuff we need. We need manufacturing. But the amount of scale we're talking here, 2,000, 10,000 acres, these numbers are insane. But we're being targeted. All we want is better protections to make sure the community's protected, the county's protected. Because right now, unfortunately, I hate to say it, but the part of the county this is going in, most of the people feel they don't have any representation. Sorry to say it, but that's just how it is right now. So
Thank
like
you,
what Hank was saying,
They've got 3 minutes.
Oh, you still got 3 minutes?
Yes.
How about it?
well,
You're within the 30 minutes, it's not a separate comment, so that's fine.
yeah, that's fine. But like Hank was saying, vote no today to get this right. Because if you don't get this right, you'll set up the county for failure years down the road. That's all I gotta say. Just do the right thing, is all we ask. Thank you, guys. Thank you.
And thank you.